Good morning. Madam Deputy Registrar, would you please call the matter?
Good morning, Judge. Thank you. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, St. Lucia, hearing of appeal in CCJ Appeal LCCV number 3 of 2024 between Exquisite Homes Limited and Geest Industries Estate Limited. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, Counsel.
Madam Justice Raj Nos Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning.
Mr. Justice Jamadar.
Good morning to everyone.
And Madam Justice Ononewu.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please you, Your Honors, Horace Fraser appears for the appellant.
Thank you. Good morning.
Good morning, Justices of the CCJ. My name is Cynthia Hinkson Ula. I appear for the appellants. With me is Ms. Esther Green Ernest and Ms. Carol Gideon. We appear for the respondent in this matter.
Thank you, Counsel.
Also present is my Douglas Rapier, who's at another location.
I see. Welcome to Mr. Rapier as well. Okay, so we are ready to hear this appeal. I believe, Mr. Fraser, you will go first. And
Yes,
is it my understanding, according to the order that was sent, that you would have approximately 1 hour?
I don't think I need an hour.
Ah, you don't need an hour. Even better. Wonderful. Thank you, sir. Okay, please proceed.
A bit of a house cleaning before we commence, Your Honors. The second ground of appeal is hereby withdrawn.
So just to be clear, I think the second ground of appeal had to do with an allegation that the Court of Appeal had not directed an inquiry into the observation concerning the breach of the implied term of goodwill in the contract, yes?
That is correct, Your Honor.
Okay, so your whole appeal then is focused on the first ground.
On the first and only ground.
Which, first and on the ground, which has to do with the repudiatory breach.
Yes.
Well,
just to be clear, you are not pursuing the good faith argument.
Not pursuing it.
Okay, good. Thank you.
I think that is tolerably clear. So the reason then you don't think you need an hour of this is because you're not pursuing both grounds, just the first one.
That is correct.
We're happy to hear you on the first ground, and first and on the ground. Thank you.
The other observation I want to make is that there was not a cross appeal in this case.
Yes.
And the counsel's skeleton argument was looking to rehash some matters that were in the code below and did not form part of this appeal and could not form part of this appeal. It was essentially a major part of our submissions. But there was no cross appeal to sustain those arguments. And so essentially what we have is this sole ground before the court for determination.
Yes.
So we will not hear you on the matter of bribe and the 75,000 or anything of the sort. You do not need to trouble yourself on that.
No, my lord.
Okay, thanks.
Wonderful. Yes. We also took note that there was no cross appeal. So you're perfectly right. Please go ahead.
My lord, the crux of the appellant's argument in this case is that the repudiatory breach occurred before the publications, the first and second publications in the Gazette concerning the acquisition. The High Court thought that that was a moot point and didn't pursue it. The Court of Appeal felt that we didn't present the evidence upon which they could rule that there was such a breach. Now, my lord, at paragraph 2.4 of our submissions, we set out the evidence which the alleged breach can be founded. And we took the court to the defense. As the first stop was the defense, the further amended defense. At paragraph 7, where the board, it is pleaded that the board, after discovering that there was an agreement, they refused to proceed with the agreement. So what we have is the attitude towards this agreement. And they set out their reasons for disagreeing. And one of the reasons that the managing director had no authority to enter into the agreement. And so they weren't going to honor it for that purpose. Then my lords will see, sorry, your honors will see that along the way, having spoken to their lawyer, they decided to embrace the agreement and then turn around and refuse again to accept it. So there was this attitude towards the agreement of not accepting it and contending that this second agreement was not valid. That was throughout the process.
Clarify something there for me, Mr. Fraser. These two bits of information which came out in the evidence, was any of them conveyed to your clients?
Which piece of information, my lord?
The two bits that you mentioned. The board making a decision that the agreement was not valid, etc. Was this board decision conveyed at that time to your clients?
None of this was conveyed.
Okay, so then continue after that then.
Yes, sir. And so we took you to the witness statements of Ms. Valerie Rapier, which was at page 234 of the record of appeal, at paragraphs 33, 37, and 38, where she recounts that she was persuaded by counsel to accept the agreement, and she indicated to him that she was going to do so, the board was going to do so. And then in another conversation, which is captured at paragraph 37, again in conversation with counsel, she indicated to him that they were not going to agree with, accept the agreement. And then at page 30, paragraph 38 of that witness statement, she wrote a letter to Mr. Labadie, who was the chief surveyor at the time, directing him that all indications or approaches by counsel who represented them at the time and the general manager to take out Parcel 314 out of the group of lands to be acquired, they must ignore that. So this was an out-and-out decision of the board that they were not going to honor that agreement.
Again, Mr. Fraser, was this decision of the board conveyed to your clients?
No, my lord. What was conveyed to my
Mr. Fraser, what I'm trying to get at is the board can decide anything until they act on it, until they convey it to your clients.
Yes,
that is purely a matter of internal deliberation, which they can disavow, from which they can move.
Yes, Your Honor, I agree with that. But what I'm doing is showing.
Sorry?
I am showing the connection with the attitude of the board and its final decision.
But Mr. Fraser, anyway, continue.
Yeah, the attitude towards the agreement.
Yes. Before you go further, could you just say this to me? There was a deposit paid by your client in respect of the 2019 agreement.
That is correct.
And was this deposit paid before the chronology of events that you're taking us through?
Yes, it was paid before.
And was there any return of the deposit by the board during this chronology of events that you're taking us through?
The deposit was returned after the gazettes appeared, the acquisition appears in the gazettes.
Yes. So my
It
brother
was
was
returned.
asking you about action which would have repudiated or disavowed the contract, and that would seem to me to be a very clear action having that effect. But you're saying that that action occurred after the land was compulsorily acquired, are you not?
Acquired, yes. But we need to connect the dots now. Now, I lay out what was the attitude towards the agreement. Then we are contending that when the agreement was reached between Geest and the government for the acquisition, and a declaration was made by the Governor General, that was the time when there was the repudiatory breach of the agreement. So by
I'm
the
sorry?
time
Sorry, you go ahead, Chef.
No, could you just repeat that? I missed you. My mind was somewhere else.
we had two scenarios, my lord. One, there was some alleged agreement between the government and the respondent to acquire the lands. That was dating back till 2016 because they had protracted talks going way back into the early 2000s, which never materialized. But some...
Was your client aware
Progress
of these talks going back to 2010?
I didn't get you, Mel.
I'm wondering whether the record reflects that your client was aware of these talks going back to the early 2000s.
These things came to my client's knowledge only after this matter came to the court.
I see. Okay.
So
Mr. Fraser, Mr. Fraser, could
Yes,
you
please.
articulate for us what are the acts that constitute the repudiation? I know you've given us sort of a context, but what is it that you are asserting are the acts of repudiation?
I was going to that, my lord. There were two
Yeah, and
scenarios.
Mr. Fraser, before you go on, the president had asked you to repeat what you had initially said.
Yeah.
Because you had said that when the agreement was reached, you said, between the parties, that was the time when the repudiatory breach took place.
Took place, yes.
Yeah, so perhaps you could, yes, answer my
Well,
brother.
I'm going to give you two scenarios which it can be hinged on. One, in 2016, when there was some agreement to acquire the lands between the government and the respondent, nothing happened. And that has been the case throughout from the history. At that time, the respondent knew that there was some agreement between them and the Crown to acquire the lands. But here they went now and entered into an agreement after that period.
Mr. Fraser,
And they had to have known that they may not have been in a position to pass a title.
Mr. Fraser, could you repeat? I'm sorry, my sister. Could you just go back? I'm trying to understand the dates that you are speaking of. When did your client know that there was something going on? I'm not sure exactly how you couching it. I'm trying to come to terms with it. If you could just repeat what you said, the last two sentences, please.
When it comes to my client's knowledge, all these things that I'm pointing to would have happened without my client's knowledge. So when the contract was executed, the first one and the second one, my client had no indication, no knowledge that at that time the respondent was making, trying to get an agreement with the Crown to acquire those lands. They had no knowledge of that. So when they entered into the agreement.
And the first agreement, not to interrupt you, just to get it clear, Mr. Fraser, the first agreement was 2016?
No, the first one was 2013, I believe. 2013.
I want you to be sure not to believe. So you're saying it's 2013?
Yes, ma'am.
And the second one was 2016?
2016.
Okay, good. Thank you.
Mr. Fraser, before you continue, I just wanted you to clarify, you have made several references to an agreement between the government on the one hand and the respondent on the other regarding acquisition of parcel 314. Can you just clarify what is the evidence of this agreement? I just want to be clear. You've used terms like they were in discussions, they were in negotiations, but you then have repeatedly used the term they reached an agreement. Can you clarify what is the evidence on the record of this agreement that you're referring to acquire the land? And you do refer to the agreement in para 2.8 of the appellant submission. So if you could just clarify what this agreement you're referring to is. Thank you.
Yes, Your Honor. If I can take you to page 179 of the record. A letter dated 23rd March 2015, and you will see that the year 2016 was written instead, because it was discovered that that letter was wrongly dated, not 2015, but should have been 2016. When the Permanent Secretary wrote to the Managing Director of the Respondent indicating that Cabinet has agreed to acquire the lands.
Mr. Fraser, thank you for pointing us to this part of the record, but I'm looking at the letter written, as you said, by the Permanent Secretary to the Managing Director of the Respondent, and it is advising or informing of the agreement reached by the Cabinet of the Government of St. Lucia to acquire in the public interest the remaining parcels of land owned by Geest. But you are referring to, as I understand it, and I really want you to be clear, you're referring to an agreement between the government of St. Lucia and the respondent regarding acquisition of the land. I am not seeing how what you've directed us to is evidence of an agreement between those two parties regarding acquisition. I'm seeing a letter advising the respondent, its managing director, of the decision that the Cabinet reached to acquire the land in the public interest. So I don't know if I'm making myself clear. Your case, as I understand it, is very much predicated on there being some prior agreement having been reached between the government and the respondent regarding acquisition of the land. So if you could point, if there's anything else you can point us to, that would be helpful. Thank you.
I wish to point you to page 354 of the record. And what you will see was a proposal being made by the respondent to the government of St. Lucia for the acquisition.
A proposal, you say?
A proposal offer.
Proposal offer. Okay.
Yes. And to understand the context in which this thing unfolded, this is 2018. The letter I just referred to you was 2015, 2016. So there's been this up and down, back and forth with the government and the respondent on the issue. And so to point you decisively to an agreement is not possible in the context.
Mr. Fraser, is that a euphemistic way of saying that you can't point to an agreement?
No,
That
what
there
I'm
was
saying,
no
I can't
agreement?
point you to a document, Your Honor.
Well, sorry, then
clearly
hold on. If there's not a document, then what is the...
We have
That's
to
serious.
we have to discern, Your Honor, that when the government made that declaration, This was the concrete step taken by the government to the acquisition. Before then, there was no declaration. There was just a promise agreement. So the only thing we could conclude then is that on the 8th of July 2019 was when the government decided fully, completely, outwardly, we are going to acquire.
Right. Which Mr. Fraser, hold on. Let's just get this clear. Which is a unilateral action by the state. That does not require any agreement. Correct?
No, the context is this.
No. Hold on. I know what you're trying to do. You are trying to say that all of that came about as a result of discussions, etc. It was the culmination of discussions, and therefore you are saying implicitly there must have been an agreement along the lines, even though there is not a documentation of this. So you see, I understand you very clearly. But what I'm trying to get you to state for us is an acceptance of the proposition that when the government acquires land, it does so in this instance compulsorily and as a unilateral action of the government, which the Constitution authorizes to be done. Is that correct?
My Lord, that is correct in relation to when the government seeks to acquire.
When what?
Because if we look at section 3,
no, you use a verb. When the government what? It says seeks to acquire?
When the government or the Crown seeks to acquire land.
But hold on, Mr. Fraser, this is exactly what you just agreed to. It's not a matter of seeking to acquire. It acquires.
Yes, my Lord. I understand that, my Lord. But what I'm saying...
Don't tell me about seeking, man. Come on.
Very well.
You're not being kind to me.
Mr. Fraser, was or was this not a compulsory acquisition under the legislation? Are you contending it was otherwise than a compulsory acquisition by the state?
I am saying, my Lord, if we look at section 3 of the Land Acquisition Act, it gives the two modes by which the government or the Crown could acquire lands. One on its own motion, compulsory, or by private treaty.
And which was this?
This is one by private treaty. So I'm saying that this is not the classical acquisition where the government on its own motion decided we want this land to pull a road or to pull a play field or whatever. This is the respondent approaching the government and saying, look, please acquire these lands for whatever reason. And this is the price we prepare to accept for the acquisition. So it's two different things. Even though it is governed by the Act and it's perfectly normal, it is not the regular acquisition, but this is one by private treaty. And we're saying because it's one for private treaty, the actions of the respondent as it regards to what they've done in relation to this, they had an obligation to the appellant to observe the contract which they signed. We're saying that when you talk about frustration, it mustn't be, the breach of the contract must not be on the fault of either party. But here we have a default by the respondent who firstly negotiated for the lands to be acquired, then turned around and sold the very lands to the appellants.
Mr. Fraser, as you're on that, where is the private treaty between these parties, between the government and Geest?
We don't have anything to substantiate a private treaty, but that is why I took you to the two letters, which clearly shows how it started and what, and if you look at the witness statements.
But Mr. Fraser, pause. Was it not what was published in the Royal Gazette? This Royal Gazette must publish the basis of acquisition. What does the Royal Gazette state?
It's set for public purpose, Your Honor.
So is that so that if it is for a public purpose, and if that's what the Royal Gazette says, where on the evidence can you argue this private treaty proposition?
The private treaty proposition is the matter that moved the process of the acquisition.
All right, so let me frame the question another way. If property is acquired by private treaty, as opposed to a compulsory acquisition for a public purpose, as you said, is also an option. Is there a different process? And are the two evidenced by different instruments?
There is no difference, Your Honor. It's an
Mr.
acquisition.
Fraser, may I help you there? Having gone through this myself personally, there is every difference, Mr. Fraser. There is a contract for sale, and then there is a conveyance by the owner to the government, where it is done by a private treaty. That is the treaty. A treaty is an agreement. An agreement is manifested in the form of a document whereby the owner transfers to the acquirer. Yeah?
I will assume so, my lord.
I'm glad. Thanks. I'm kind.
So, Mr. Fraser, therefore, if you assume so, then in this case, the publication in the Royal Gazette of the acquisition is not consistent with your thesis of a private treaty, is it? Isn't that a challenge that you have? That the publication in the Royal Gazette suggests that this was a compulsory, whatever happened, it ends up as a compulsory acquisition.
That is correct, Your Honor.
All right.
But our contention was, it's one of a private treaty. And regardless...
But Mr. Fraser, we'll take the argument, but when we review the note of the conversation between Justice Barrow and yourself and myself, I think it speaks for itself.
Yes.
Your argument of repudiation, at some point, please tell me, what is the evidence in this case? What are the acts of repudiation? You said you were coming to it.
No, but what I've said, and I will repeat, is that while the government was negotiating, or while the respondent was negotiating with the government, that process.
So the repudiation, that is to say, the breach of the what goes to the breach of the entire contract, the root of the contract, you are saying, is the fact that they were negotiating with the government to have the government acquire the lands by private treaty. That is repudiation.
What I was saying, Your Honor, is that when the declaration was made by the Governor General, this was Geest saying to the appellant that we are no longer bound by this contract because we have now organized to the government to acquire these lands. And so we are not honoring our obligation to you. The effect of what they did is to say that to the appellants, we are not honoring the obligation. And that came before the publications. So this is what the law courts did not appreciate, that all of that happened. And so when there was a publication, there was no contract. Contract was already gone. So to talk about frustration, it means that the contract had to be in existence when those publications were made. To take it in the Johnson case, this case falls out of the Johnson scenario. There was a breach before the publications, first and second. And this is where we are. Because while the government has a right to acquire, Geest does not have a right to enter into a contract and then negotiate for an acquisition in respect to the same piece of land. And this is the scenario we have.
Yep, I think we understand you. Did you want to press any other point?
That is the gravamen of the case that the appellant is asking the court to consider.
Mm-hmm.
The whole conduct of the respondent towards the contract.
Yes. Yes. And as I asked you before, the deposit was returned after the government acquired. Right.
Yes.
Okay. Anything further?
No, unless the court would want me to address anything. It's a fine point.
It is a fine point, yes. I appreciate that. Colleagues, anything further? No?
Mr.
I have
Fraser,
heard fully
fine.
from Mr. Fraser.
When you say a fine point, you mean fine as in good quality or fine as in a narrow
Fine as in
distinction
small,
or
small,
both?
not elaborate, not very
Right.
complicated.
Yes.
All right.
Thank you,
good.
sir.
Thank you.
Appreciate your submissions. Counsel for the respondent.
Milords, milady, as
I think it's traditional in the court to refer to the judges as your honors.
Oh, your honors. Thank you
Yes,
for the correction.
no, that is fine. That is fine. We're trying to ensure that there's no mistake between us and our predecessors.
Thanks.
Yes.
Your honors, having listened to Mr. Fraser's submissions, it's clear that the ground on which he relies cannot succeed because he has not produced any evidence of a repudiatory breach. And he has conceded on all of the points which clearly make it safe for the courts to uphold that the compulsory acquisition in fact frustrated the agreement which was in place. However, Milords, having said that, I want to make the point.
However, your honors.
Sorry. Having said that, I would like to make the point that in view of the conduct over the second agreement, which is the 2019 agreement, that agreement was in fact void. And if the court could permit me to
Sorry, the High Court held it was valid. The
Yes.
Court of Appeal held it was valid. You have not appealed those decisions.
Yes.
So on what basis are you now arguing that it was void? You have not crossed appeal on that decision, have you?
Your Honor, I agree with all of the statements. Yes. However, I asked the court to take into account the fact that the High Court and the Court of Appeal came to the decision based on what inferences. It was not a primary fact. And this court has before it all of the material to determine that fact.
But counsel, wouldn't you agree though with the president that you did not cross appeal on this matter? If it was so important that you would want us to take all of these things into account at this stage,
I will agree.
Would that be fair to the other side?
Firstly, my lady, I will refer the court to Your Honor. Sorry, I will refer the court to Section 28(2) of the Supreme Court Act, which in fact permits the court to hear these arguments, despite the fact that there was no cross appeal.
Counsel, may I help you here? And I'm trying. Do you need to get into this thing about void? The court, counsel, work with me, please. The courts have decided the agreement was frustrated. The effect of frustration is that the agreement no longer exists. Now, the proposition that it was void does not put you any further in terms of the outcome as the proposition that the agreement was frustrated. Why do you want to go down the road of void? And with respect, before you answer that, to my mind, that would be a rank abuse of process to be raising for the first time a fundamental point as to the validity of the agreement based upon it being void. But tell me, Why, given that you have a verdict of frustration, do you need the agreement also to be void? Help me.
Millard,
Your
Honor, sorry. The reason for this is because I will not press the point, but I will give my reasons, and then the reason for this is that when one looks at the whole scenario and the approach taken by the lower courts regarding the presumption of a secret commission in those circumstances, and stating that it is the burden of proof lies on the would have laid on the respondent and not on the appellant. I think that is a point, a general point, not just for this case, but
Counsel,
generally.
with respect, if I may help you, you are totally, I think, out of order in trying to once more sneak your secret commission and bribe point onto this court. Mr. Fraser very graciously yielded his second ground of appeal, and in his remarks yielding, he also pointed out that absent any cross appeal, the matter of the $75,000 payment had no leg on which to stand. I urge you to please consider whether you want to go down that road, because the next thing I will do, if you keep going down that road, is to say to you, did you ever consider that you ought in the High Court to have made a claim, joined the managing director and counsel acting at the time in a claim in which you claimed against them in the same set of proceedings for damages for entering into this bribe arrangement of which you speak, conspiring to injure the company by entering into an agreement which was, in terms of the prices paid, etc., to their significant disadvantage, etc. So not having in the High Court brought a claim against them, which you could have done in the same proceedings, I am really suggesting to you, leave void alone. Okay, thank you.
I do believe, ma'am, that you did try to make an ancillary claim, but the procedural rules went against you, and they were not continued. That claim was not continued. But ma'am, I think Justice, my brother has given you some very good advice. We wouldn't want costs to be an issue for you at this stage.
I take your advice, and I'm grateful. So, in view of what the concessions my learned friend has made, I do believe there's nothing further on which I need to address the court unless the court requires me to do so.
Yes, I'm interested in one small thing. I think I asked Mr. Fraser about this. From the record, can you say when it is that the appellant first became aware that there was negotiations between your client and the government for the government's acquisition of the land?
From the record?
Yes.
My client would not, my client would not be aware of
when the other party became known. Okay.
No.
All right, because I know that there was this initial agreement in 2013, which fell through, and then there was the agreement in 2019. But all that time, and before that, there was a negotiation going on. So I just wondered whether the record revealed the dates of when that became sort of public knowledge, or at least knowledge in the to the appellant. But if you don't know, that is fine. It's nothing turns on that. Is there anything further you wish to press on us, or are you taking the advice of the judge here and resting on what you have said so far?
I am taking the advice of the judges and resting on what I've said so far.
Thank you very much. Absolutely. I see no further questions for you. Anything in response, Mr. Fraser?
No, Your Honor. I've known by practicing before Justice Barrow is not to fatigue him unnecessarily.
I don't think it becomes easily fatigued, I assure you. Okay.
Mr. Chair?
Yes, sir, please.
If I may be permitted, just to advert to my time when I was stationed in that fair jurisdiction, to say what a pleasure it is to see at least 3 of the regular practitioners who appeared before me then, appear before me now, and having all distinguished themselves so very well. Thank you.
Thank you very much. Okay, well, there be nothing further. I would invite Madam Deputy Registrar to close the proceedings.
Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajna Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamada. And thank you, Madam Justice Unonu. Thank you, Counsel. And a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you.